All right, I'm going to admit them now. Good morning, everybody.
Morning, Judge.
All right, this court of the 19th Judicial Circuit is now in session. Welcome, everybody, and thank you for appearing here today via Zoom. Right now, some of your microphones are muted. I just ask that you, if there's going to be any background noise or anything like that in the area that you're in, to keep it muted until you talk. If not, we should be fine. My intention is just to run this the same way I would run any court call. Each side will get an opportunity to plead their case. I keep in mind that this is a formal proceeding, and please treat it as such. I will make sure, as I said before, everyone gets a chance to address all of their issues. Finally, I also want to say that these proceedings are being streamed live on YouTube. That's how we are presenting and allowing public access to this proceeding. Nobody other than an official court reporter is allowed to record these proceedings in any way. I want to make that announcement. And anyone that violates that court order not to record can be held in contempt. Any questions before we get started?
No, Judge. Not for me.
All right, excellent. So I would just like everyone to know this is Dmitry Blinman and Shakov versus Vishnevsky. Is that correct? We're here on the right case.
Yes, Your Honor.
L553. I'm sorry for butchering those names ahead of time. I have had an opportunity to read the motion for summary judgment, the reply, the response, all of the attachments. I had an opportunity to look through the case law that was cited, and I am ready to hear arguments. Who is defense counsel? Whose motion is this?
That's
All right.
me.
I'm having a little trouble hearing you. Go ahead and speak up.
Okay. Can you hear me better now?
I can hear you perfectly now. That's great. Are you ready to begin?
Yeah.
All right, go right ahead.
All right, Judge. So this case obviously arises out of the sale of a home that the plaintiffs bought from my client, Dennis Vishnevsky. And before they bought the home, they saw a listing online. They went to the home on several occasions. On one of those occasions, they were accompanied by a home inspector. After that, they went back to the house a couple of times, walked through the house just to check on everything, make sure they were satisfied with the condition of it. And then before they finally took possession, the plaintiff, Blinman, looked through the home, inspected it himself without any furniture in it, no rugs, nothing. And he said, okay, this house is good for me. And he took the keys, took possession of the house, lived in it for months, and then at some point became unsatisfied with the condition of the house. And about a year after he took possession of the house, he sued my client, Dennis Vishnevsky, and the realtor Oksana Melnichin. And the plaintiffs alleged that my client concealed several defects in the house. And they bring 4 different causes of action. But really, the gist of everything is that Dennis Vishnevsky hid all these very severe defects in the house. And Judge, as I state in the motion, there's no evidence that any of these alleged defects existed when Dennis lived in the house or he knew of them. And there's certainly no evidence that he ever did anything to conceal them from the plaintiffs. It's quite the contrary. And as I set forth in the motion, Dennis moved into the house in 2013. He lived there with his family. He never had any problems. He never had any work done. There's no dispute about that.
Well, I mean, he had the skylight painted several times, and he put down some concrete near the garage. And I mean, I'm not going to go over all those, but
yeah, right, Judge. And I guess what I'm saying is he never had any contractor come repair a roof. You know, he didn't have any big problems that needed to be fixed. He had minor little cosmetic things done here and there. Just every year he would have somebody come spruce up the house. And as you saw, as I pointed out in the exhibits, all the furniture, all the rugs, everything, it never moved the whole time he was there. But plaintiffs, really the essence of their complaint is that Dennis placed furniture and window treatments over these defective areas. And we know that's just not true. They were there the day that he moved in, and they were there the day that he moved out.
And we know that from Dennis's affidavit?
Not just his affidavit. Yes, Judge. But then in the attachments to the affidavit, we attached an appraisal that was done in 2013, just after he moved into the house. And when you compare the photos from that appraisal, they show everything, the exact same furniture in the exact same places as when the plaintiff's inspector inspected the house after they agreed to buy it. And so, Judge, I can get into the fraud claim, but I was planning to kind of start with what I think are the slam dunk causes of action, and those are the implied warranties. And so first I was going to address the implied warranty of workmanship, which clearly doesn't apply to this transaction. Now that warranty arises out of a contract between a homeowner or a home buyer and somebody who's a builder, contractor, or craftsman in the construction trade. And that's a direct quote from the Board of Managers of Park Point case. Here, there's no evidence that Dennis is part of is a builder, a contractor, or involved in any way in the construction business. He works.
What he did again, though? He was with a management company of some kind?
He works for a property management company. And so he oversees the staff and operations, those types of things. And I asked plaintiffs in their deposition, hey, what do you think Dennis Vishnevsky does for a living? Oh, he works at a property management company. He's pushing paper. I said, are you under the impression that he uses hammers or tools or, is any sort of skilled workman? Oh, no. Because we're not. We all know what a property manager does. And then the other thing is, even if he did qualify as being that type of, having that type of occupation, it doesn't matter for this claim because this claim arises out of a contract between the plaintiff and the defendant. And as I pointed out, there was no contract for any services provided. And they admit that in their request to admit responses. And so, Judge, just as a matter of law, that claim fails.
So it was just a contract for, in other words, what you're saying, it was just a contract for sale, not a contract for building or.
Exactly. They didn't hire him to fix something in the house or to build something for him. And that's the sort of contract that this implied warranty may arise out of. And moving to the second implied warranty, which is the warranty of habitability. Again, this warranty applies only to builder vendors that sell a home for a commercial purpose. And going back to what Dennis does for a living, he works at a property management company. He's not a builder vendor. There's no evidence that he's ever built a home or rehabbed a home to sell it. He bought this house. He lived in it with his family for 3 years. He's a younger guy. I mean, he's a little bit older than me, but this was his first big house, and he had some kids, and he moved out to a bigger home afterwards. There's no evidence that this was a commercial transaction in any way. It just was just as anybody out there, as would they buy a house, they live in it, and then when they decide to move on to graduate to something bigger or to downsize, that's what they do. And the plaintiffs point out in their response brief, well, it was for a commercial purpose because the home sold for more than he bought it for. Well, no case has ever said, well, okay, if the home increases in value, that makes it a commercial purchase. I mean, Judge, I'll tell you right now, I'm looking at buying my first home, and of course, I'm investigating well. In 10 years, maybe, is it going to be worth more than it is today? I certainly hope so. And so, the other thing is the plaintiffs inflate the quote gross profit that he made. I mean, that number's inaccurate, but the point is it doesn't matter. He's not a builder vendor, and it wasn't a commercial transaction. And so, Judge, that claim fails as a matter of law as well. And so now I'll turn to the fraud claims. And it's, in my opinion, it's sort of a shotgun complaint. When you read it,
can I stop you for just a second? Because
Yeah.
I just want to anticipate an argument that they're going to make, and that is, yeah, he did live in it, but he bought it to flip it, say, did he ever do this kind of thing before? Is this the first house he ever bought? Or
first house, Judge, I'll tell you, he bought a townhome, lived in it, and then he got married, and his wife had a kid. They had another kid. They moved into this house. They had another kid, and he's rising up in his employment, and he moved to a bigger, better, nicer house. That's all it was. He didn't flip it at all. And Judge, there's some. I understand that thought, but he bought it in foreclosure. He got a good deal on it, and he fixed it up. He planned to live there for a while, but things changed. He had a bigger family.
Okay.
And so,
go ahead.
As to the fraud claim, in this context, to prevail against a home seller for fraud, the plaintiffs will have to prove that there were defects that existed at the time of the sale or prior to, that the seller knew that they existed, that the seller actively concealed the defects, and that the plaintiffs could not have discovered the defects upon a reasonable inspection. And as I set forth in the brief, they won't be able to meet any of those. There's no evidence to support any of those elements. And I'm going to start on the first floor, Judge. A big chunk of their claim has to do with windows that they contend are leaking. And Dennis, of course, says he never saw any leaking windows the entire time that he lived in the house. And as the plaintiffs point out in their response brief, the court's not required to accept just the self-fulfilling averment in an affidavit by a defendant if there's evidence to the contrary. And the cases that they cited provided examples of such evidence. And you look at the types of things where courts have found, the seller says he didn't know, but look at this other evidence, he must have known. And you look at the Woods case, where they said, hey, don't know anything about leaks or floods, but it turns out they had hired somebody, I think, 4 times in 5 years or 5 times in 4 years to repair some leaks, and they admitted that it flooded twice. And Judge, I'll point out that's a real property disclosure act case, not a fraud case, but it gets to the same point of the seller's knowledge.
Right, exactly.
You look at the Crew case.
I mean, if there's disputed issues of fact in this case, I mean, I don't want to short circuit anything, and I'm sure the other side would agree. If there are questions of material fact here, they surround what the defendant's knowledge reasonable beliefs were those type of issues surrounding fraud and the Real Estate Disclosure Act.
Right, of course. Yeah, the knowledge comes into play for both causes of action, right? Look at the Crew case. Water-stained furniture was removed. New furniture brought in right before the sale. Somebody hired a contractor, come in and fix up the basement right before the sale. None of that happened here. You look at the Meserly case, where the seller sells the house, and then shortly after the buyer moves in, says, "Hey, I'm having a leak. Do you know anything about this?" And the seller says, "Oh yeah, here's what you do. Go into the bathroom, undo this valve, fix this pipe." And so the court said, "Well, hey, you can't tell me you didn't know anything about the leak when you knew exactly how to fix it." And then also in the Messerly case, there's structural problems that the buyers find out about. And then they learn later, the seller says, "Hey, I didn't know anything about it." They learn later that he made an insurance claim about it. So he clearly knew about it. Here you have nothing. You have absolutely no evidence that Dennis had any knowledge of a leak in any of the windows. And again, I'm going to point your honor back to the fact that the window treatments that he installed, or he or somebody that he hired installed the day he moved in, they're the same. The entire time he lived there, they're the same. And so plaintiff suggested there's this huge water leak problem. Well, then surely the window treatments would have been damaged. They had the same stuff there the whole time. And no evidence of repairs, no evidence of an insurance claim. There's just simply no evidence that Dennis had any knowledge of any problem with the window leak in the living room or in the dining room. And turn it to the next point. Even if it was there at the time, it would have been discovered upon a reasonable investigation. And that's not me saying that, Judge. That's plaintiff's own expert. Priscilla Johnson, their expert witness, says, "Oh yeah, there's a whole showing around here, and if somebody did a real reasonable investigation, they would have found it." And since we know that, the claims fail, because you can't have something that can be reasonably discovered and then claim that it was hidden from you. And then that just sort of brings me to the last point on the windows, is this idea that Dennis installed the window treatments to conceal them, to conceal the defects from the plaintiffs. Again, I know I keep going back to it, but Judge, he installed them in 2013. No reasonable person is going to conclude that Dennis moved into this house with this family and installed window treatments to hide supposed defects from somebody years later. Never fixed them, nothing. He just put up window treatments and for the purpose of hiding them from some hypothetical buyer years down the line, should he choose to sell the house. That's not a reasonable argument, Judge.
What about if the window treatments, he didn't put them up for that purpose, they existed the whole time, but they still concealed a defect known to him?
Well, Judge,
he didn't disclose it. Would that be a violation?
Not necessarily. If there's two points there. One, if he knew about it and the window treatments, couldn't be moved or something, and then they concealed it, maybe. But that's not the case here, because like I said, one, there's no evidence he knew about it. Two, plaintiff's own home inspector testified that when he went in there, he examined them. He says he went in there, and I asked him, I said, "Mr. Hanna, if there's window treatments that prevent you from inspecting a window, do you open them up?" "Yeah, of course," he says. Then I say, "If something prevents you from inspecting a window, would you make note of it in your report?" "Of course I would." And there's no notation in his report. He says, "I inspected the windows, the walls around the windows in both the living room and the dining room, and they were fine." And so, Judge, as for the windows, no evidence of knowledge, no evidence of concealment, and they would have been discovered upon a reasonable inspection. So the window claims there's no evidence that they could prevail on those, and Dennis is entitled to judgment on that. And I'm going to stay on the first floor, Judge, and we're going to talk about the living room floor. The plaintiffs claim that there's cupping and buckling in the living room floor, and they suspect that it was maybe caused by some massive water event. Again, no evidence of any water event in the house. And I'm going to point your honor back to the fact that the same rug, the same furniture, everything was there the entire time that Dennis lived in the house. If there's some big flood, the same rug isn't going to stay there for years. And Dennis says, look, I had no problems with it. Never experienced it. And I'll point out, your honor, it was a brand new floor. He had the floor put in, it was brand new. And the plaintiffs, again, they say, well, Dennis placed the furniture to cover it up. Well, I'm going to bring your honor back to the argument that he didn't place the furniture there 3 years in advance to conceal a defective floor. It's just not a reasonable argument. And then even if he did, though, but even if he did, the plaintiffs inspected the house without any furniture in it. So there can't be any concealment. All the furniture was out. They're in the house for hours before they take possession. Nothing in it. And they didn't say anything about the floor. The floors were fine for them. And the last reason that the claim fails, Judge, is, as their expert says, this issue would have been discovered upon a reasonable investigation. And so again, no knowledge, no concealment, would have been discovered upon a reasonable investigation. The claim, Dennis is entitled to judgment. I'm going to move to the garage, Judge. There's two complained of defects in the garage. One of them is that there's a beam or a post that supports the second level, and apparently the post isn't on the proper footing. And Judge, I'm going to tell you that my client Dennis Wisniewski has no knowledge about what sort of footing a support post is supposed to be on. The footing is below several inches of pebbles. The plaintiffs found it because one of their experts went in there, dug up the pebbles and looked down on it. There was no evidence that Dennis ever dug up those pebbles himself and looked at the footing and examined whether it was proper. And even if he did, he wouldn't know. He wouldn't know what type of footing that post was supposed to be on. He has no knowledge on that subject matter. And now turn into their supposed act of concealment. Dennis moved into the house, and within days, he got annoyed by his daughter throwing the pebbles around the garage. And so he goes to Home Depot and says, hey, I want to cover up some pebbles. What should I do? They give him some concrete, and he puts a very, very thin little layer of concrete around the pebbles within days of moving into the house. And Judge, again, I'm maybe going out on a limb here. I mean, I don't want to speak for Dennis necessarily, but Dennis would never find some structural problem within days of moving into the house and just say, forget about it. I'm going to live here anyways. I'm going to let my kids play in this garage every day. Those types of things. It's just, it's an unreasonable accusation. And no reasonable person would say that, yes, this was an act of concealment that he knew about. He knew about the issue. He put the concrete there to conceal it from anybody in the future finding it, should he choose to sell the house several years later. And so, Judge, on the post claim, no evidence of knowledge, no evidence of concealment. Dennis is entitled to judgment. Moving to the
hole in the garage ceiling.
The garage ceiling. The garage ceiling, Dennis says in his deposition, he says, oh yeah, when I moved into the house, I saw the garage ceiling had, the drywall was a little bit off, but nothing ever happened to it the whole time I lived there. Never got worse, never saw any water damage, nothing. And plaintiff's own inspector went into the house and he says, I inspected the walls, I inspected the ceiling, There was no evidence of a water leak anywhere. There was nothing. And now they point to the fact that there's water damage several years later. Well, that doesn't mean that it existed at the time. We all know, and plaintiff's experts both testified. I asked them both, hey, can a water leak develop at any time? They said, of course. And so just because there's a leak now doesn't mean that there's a leak then. That's not evidence that a leak existed at the time. But even if it did, again, plaintiff's own expert testified, would have been discovered upon a reasonable inspection if it existed. Claim fails for that reason too. Fails for another reason. Their allegation of concealment is that the garage door was up and when the inspector went through the house. And that allegation has no basis because the inspector admits, oh no, I inspected the garage when the garage door was down. I looked through it, I opened and closed the garage, and I looked at the ceiling when the garage door was down. So there's no concealment. The claim can stop there. So again, Judge, no evidence that it existed, no evidence of knowledge, no evidence of concealment, the only evidence is that it would have been discovered upon a reasonable investigation. Dennis is entitled to judgment on that claim. The judge, we're going to move upstairs. We're going to go to the master bedroom where the plaintiffs allege in their complaint that there's a supposed slope in the floor and that some of the trim around a door is offset or something like that. And again, Judge, their allegation of concealment is that, well, Dennis placed furniture over the slope in the floor. And we're going to go back to that point, Judge. Nothing moved. None of the furniture moved the entire time you lived there. There was no concealment. There's no evidence of any act of concealment. And then we also turn to the fact that even if he did place it there for that purpose, the plaintiffs went through the house with no furniture in it for several hours. No furniture anywhere. The other thing is, just like every other defect, their expert says, oh yeah, would have been discovered upon a reasonable investigation. So it fails for that reason above. That reason as well, and Judge, I'll note the plaintiffs did not respond to that argument in their response brief. The master bedroom claims went unanswered. Dennis is entitled to those to judgment on that claim. Moving to the skylight, Judge. Probably the more contested claim in this case. When the plaintiffs went through the house for the very first time, and they said this in their deposition, they noticed that the paint around the skylight was a fresher coat than the rest of the ceiling. And then when they went through with their inspector noticed it too. And so they asked Dennis, or they asked the realtor, will you please find out why that's painted? Dennis tells the realtor, I have it painted every year because there's condensation that appears during the wintertime after I shower. Every year I hire my guy, Roman, he comes and he touches up the house. That's one of the areas that he touches up. And he told plaintiffs that, and they said, okay, well, we're fine with that. And this is actually the defect that kicked off this whole lawsuit, because after they moved in, several months later, they noticed some streaks start appearing along the ceiling around the skylight. And Judge, they say it started appearing when the weather turned and when it got cold outside. That's exactly what Dennis said would happen. And I asked him, I said, okay, so you guys allege that there's a leak, right? Did it ever leak when it rained in the first 4 months that you lived in the house? No. Did it ever leak when it snowed? No. And I asked their experts. I said, if a leak existed during those first 4 months, when it rained, would the water seep through? Yes, of course. And so, again, Judge, No evidence that Dennis ever had the drywall around it repaired because apparently it's been pouring rain through for 3 years. That never happened. No evidence that Dennis ever had somebody come look at it because he's concerned about a severe leak. Nothing. He saw watermarks that he thought was from condensation. And Judge, I think we can all relate to condensation appearing on ceilings and bathrooms. I know growing up, my mom went up and painted it every year. You know, it's not like he just made this up out of thin air. It's a very sort of common sense explanation where there's no water coming through. What else could be causing these little streaks? He believed it was condensation. But even if there's a question of fact as to whether his belief was reasonable or something like that, under the Smith versus Ethel case, once Dennis told them, hey, I had water streaks from condensation, that put the plaintiffs on notice. There might be an issue with the skylight. And they had an obligation to go investigate what it was and determine whether they wanted to go forward with the transaction or not. They didn't do that.
I mean, aren't they just allowed to rely on his representation that it was condensation and not a leak, which is, I think is what they're alleging, that it is a leak?
No, Judge. Once they're it's like in Smith versus Ethel, there's a leak in a roof, and the seller says, buyer says, hey, what's going on with that leak? And the seller says it's from the air conditioner. And the buyer says, well, I want to go up and look at it. And he says, he actually prevented them from going up there. He says, there's no lights. There's nothing you could see up there. Don't go. And so they didn't go. And the court said, look, you're on notice that there may be an issue up there. That's on you. If you didn't further investigate it, that's on you. You can't rely on what the seller told you. Once you're on notice, you have to figure it out. And so, Judge, again, the last thing is getting back to this idea of concealment. He told them about it. It's not like they took possession of the house and later on they said, hey, what are these water streaks? And he said, oh yeah, by the way, there's condensation. You just got to paint over it every year. He told them from the beginning, oh yeah, these things appear. I painted over it. And so that's not concealment, Judge. He told them what he believed was the truth. And so for those reasons, Judge, I submit that he's entitled to judgment on the Skyleak claim as well. And now I'm going to move to the square footage claim, but first, there's several allegations in the complaint that are vague, and there's problems with the roof and the chimney and various windows. And as I stated in the complaint, Judge, the two areas that were actually discussed during discovery was the roof. And I said, what's wrong with the roof? Oh, it's old. Did Dennis conceal anything wrong with the roof? No. Okay, well then, he's clearly entitled to judgment on that claim. Same thing with the chimney. I said, what's wrong with the chimney? Well, there's certain things wrong. I said, how did Dennis conceal the chimney from you?
But if I could just say, but you're not asking to strike or to because that's part of an overall claim. There's not a separate claim for each one of these particular defects. There's a claim of fraud. There's a claim of failure to disclose. Yeah. So this is not really a motion in limine to bar them from presenting evidence regarding, say, the roof, alleged roof defects, or the age of the roof, or something like that, is it? Or
yeah, kind of, Judge. Yeah, because at this point, I've been on the case for a little over a year, and I've been going through, and every time I try to narrow in on where the defects are, the goalposts move and they get wider and wider. And so that's part of my strategy with this motion, Judge, is to narrow down. If we're going to trial, I need to know what I'm defending against, because they have no evidence related to any defect in the roof, but yet I'm going to have to prepare for some trial related to the roof. I think that he's entitled to judgment on those parts of the claims where the plaintiffs just have no evidence whatsoever. And so I don't know if I answered your question, Judge, but
Oh, that's okay. You think you have.
okay. And so, within that is like there's some mold or different allegations that just were never substantiated. He's entitled to judgment on those claims. Moving to the square footage, Judge. The plaintiffs allege that Dennis fraudulently misrepresented the square footage in the house because when they first saw the listing, it was listed as, I think, 2,988 square feet. And then after they saw it, it changed to 3,200 or 3,248 square feet, I think is what it was. And they say, well, that Dennis committed fraud. And Judge, I'll point out, just from the beginning, that claim fails. They have no evidence that the home is not 3,280 square feet. There's no evidence. They haven't come forward with any number as to what the actual square footage is. The husband and the wife each told me it's a different number. They just rely on the fact that in the first listing it was one, and then in this later on it was updated to a new number, and so therefore the second number must be false. That's not evidence. That doesn't prove that the statement was false. But even if it is, it wasn't a statement made by Dennis. Dennis had no control over the listing. Dennis had no control over what, her name was Oksana, over what the realtor Oksana put into the listing. All Dennis said was, hey, Oksana, I have an appraisal, and I talked with the guy when he did the appraisal, and he showed me areas that he thinks weren't measured in the past, and I believed him. And so this is the appraisal that I think is the most accurate. If you can list it up there, great. If not, I understand. And she said, yeah. And so you can't impute that decision onto him. It's not a statement by Dennis. And then plaintiffs sued both Oksana and Dennis, but they settled with Oksana. So they settled that claim based on the square footage with the person who actually made it. Yet they still want to hold Dennis accountable for it. Can't do that. They released the square footage claim when they settled with Oksana. But most importantly, the most important part about this claim is before the plaintiffs got the house, they had their own appraisal done. Their own appraiser measured it at 3,099 feet, which is different than both the square footages that were in the listings. And at that point, the plaintiffs were on notice that there was a discrepancy as to the square footage. They were on notice that the 3,240 square feet might not be accurate. And Judge, I cited, it's an often cited quote, and it says a person may not enter into a transaction with his eyes closed to available information and then charge that he has been deceived by another. That's in the Smith versus Ethel case, and it's in a lot of other cases. And that's exactly what the plaintiffs try to do here. They were on notice that there's an issue to the square footage potentially, and they can't just say, oh, well, we relied on the one that Oksana put in the listing. That's not reasonable reliance. Dennis is entitled to judgment on all the square footage claims. Finally, moving on to the statute, Judge. As I've explained today, the same defects that they complain of in their fraud claims form the basis of their violation of the Residential Real Property Disclosure Act claims. Again, under the Act, you're only liable for not disclosing defects that you knew existed, right? Like that's obvious. And as I explained today, Judge, there's no evidence that Dennis had any knowledge of those defects. And so that aspect of their statutory claim fails for that reason. But then they also allege that Dennis violated the Act by failing to supplement his disclosure report to reflect the information contained in their inspector's inspection report. And Judge, I'll admit to you, there's no dispute. There is a provision within the statute that says if you made an omission, if you made a mistake when you first filled out the disclosure form, you got to go back and supplement it. If you fill it out and you remember, hey, this, I forgot I got this fixed, I had this leak, you have to go back, you have to supplement it, you have to let them know, hey, this happened in the past, this is what you're buying. No case has ever applied this, what I characterize as a nonsensical interpretation of the statute, where you have to go back, take the plaintiff's expert's report, get a supplemental form, and then add in everything that their expert found. Yeah, that's not what the statute is intended to do. The statute is intended to protect the buyer, not punish the seller, not place some undue burden on the seller. And having the seller, copy paste the buyer's experts or the buyer's inspector report onto a supplemental form does nothing to protect the buyer. You're just disclosing information that they gave you. That's an unreasonable application of the supplement provision in the statute. And so for those reasons, Judge, he's entitled to judgment on, at the very least, the supplement claims, and also just the regular claims, because he had no knowledge of the complaint of defects. And I think that covers it all, Judge.
All right, Mr. Mathis, we will get back to you. Who's going to be arguing for plaintiff?
Sorry, Judge Alan Friedman, on behalf of plaintiff.
All right, go right ahead, sir.
All right, Your Honor, thank you. I believe we got to start from the starting point. And counsel keeps saying no evidence. He's entitled to judgment. That's not why we're here. We're here for a motion for summary judgment. And a motion for summary judgment, they bear the burden to prove that there's no genuine issue of material fact. I don't have to present evidence. He has to prove that there's no issue of genuine issue of material fact, and they failed to meet that burden, Your Honor. The plaintiff opposing a motion for summary judgment does not need to prove his case. All he needs to show is that there is a genuine issue of material fact that could arguably support judgment in his favor. So when counsel talks about it's a combination of a motion to dismiss, a combination of maybe a closing argument, but it's not the standard for summary judgment. Summary judgment is there a genuine issue of material fact for the court to decide? And we believe there is. Counsel kind of jumped around a little bit here, but I think the crux of it, if you look at it, we allege 5 categories of defects. They admitted to 3 of them. Now, counsel testified a lot, which is great, but that's not facts. It's not supported by the affidavits, the exhibits, the pictures. Mr. Wisniewski admitted that he painted every year. Every year he painted the skylights. He claims in his affidavit he has no special knowledge of real estate, of construction law, but he also admits he never had a roofer look at it. He never had anybody check out the window. He decided it was condensation. Again, he admitted he knew that. That should have been disclosed under the Residential Real Property Disclosure Act 4.
Can I ask you a question? Can we start, though, with the implied warranty of workmanship count?
Sure, Your Honor.
I'm just trying to keep in mind, I don't mean to make you jump around. I promise you can get to everything. I'm just trying to keep it clear in my notes. What is the evidence there? Why is there a claim for an implied warranty of workmanship under these circumstances? So
Mr. Wisniewski testified, and he gave us Exhibit 4. If you look at Exhibit 4, a list of improvements of over $108,000 of repairs. Okay. Mr. Wisniewski's entire career has been property management in various different forms. He testified as a property manager that he reviews bids, he does underwriting, they buy building, repair buildings. When we were handed that exhibit, when we were looking at the property, Oksana, the realtor, got that number, that very detailed spreadsheet to my clients and said, look at all the repairs. They listed this as a highly upgraded home. Now, because when I asked him at his deposition, who was a general contractor? Well, there wasn't a general contractor. He hired the subcontractors, he selected the materials, he scheduled their work, he paid for it. That's a definition of a general contractor. That's what general contractor does. And we say case law that all general contractor is basically a project manager. It's somebody that schedules work. There's no general contractor to sue. The other issue, if you look at anyone who buys a fixer-upper becomes a contractor? No, you're not necessarily on it. If you look at the Park v. Sun case, where the Supreme Court discussed that one, it was the first time Mr. Park had built a house for himself, and then later on he decided to sell it. And even though he built one house, the court still determined he was a builder vendor. In this case, we had Mr. Wisniewski sold prior to this one. He testified a townhome. I assume he made a profit in that one. And in this one, he held the home for a little over 3 years, made a gross profit. He sold it for $693, almost over $180,000 gross profit. I didn't.
But I mean, how much did he put into it, though? I mean, you're saying that it was.
That's the question. He gave us a list of $108,000 of repairs, arguably, but we asked him for receipts. He didn't have a single receipt. He didn't have a single check. He didn't have anything. He just said, "This is what I did." And then when when Oksana was showing the house around to my clients, he said, "Look at all the work that he did. He's in police should testify. He's in real estate. That's why this house is worth so much, because it was highly improved." And then if you look at the court's recent Supreme Court's holding the Sienna condominium case, a homeowner cannot sue a subcontractor. We can only sue the general contractor because of privity of contract. In this case, there's no general contractor other than Mr. Wisniewski. There doesn't have to be a special hat that he wears or a license to be a contractor, but he did the function of a contractor. He selected the floors. He selected the tradespeople. He selected where they're going to be installed. And we have a right under Illinois law to assume that he did it in a proper manner. And because he didn't do it in the right manner, we can't use certain parts of the house. The floors are damaged and weighty. They have to be entirely replaced. The windows are damaged, caused leakage throughout. If you look at the pictures, all our experts testified that the damage that was caused was not a one-time leak. These were chronic conditions. And I know that gets more into the RRPDA argument, but the leaks, the split header in the dining room, where he testified on Exhibit 4 that he put in a security system, all the windows had a security system except the one that had damage on. Again, I think there's a genuine issue of fact whether he is a builder vendor. And under the holding of the Park v. Sun case, the commercial intent, I can get that one section here. The commercial intent does not have to be at the time he built the property. It could come later. Sorry, I had it going in a different way.
Okay.
Yeah, so in part, the builder vendor, the court found had built and sold one house before. The courts held it was not necessary to have a full-time professional builder. The court held that the sale of a house by its builder had been a commercial sale, even though the builder began construction for his own family when the course of construction decided to sell the house. So Mr. Wisniewski built this house, he fixed it up. 3 years later, he sells it for over a gross profit of over $180,000. There's no general contractor to sue. Under the Sienna condominium case, I can't sue the subcontractor to put the floor in because I'm not in privity of contract with them. I'm only in privity of contract with the person that did the work. Under the holding of Park v. Sun.
Privity of contract. This is a contract for sale. It's not. It wasn't a contract for. You didn't contract with him to build this house, or you didn't contract with him to do any work on the house. Isn't that
correct, Your Honor?
But party of workmanship goes to? I mean, but I'm just separating out workmanship from habitability.
Yeah, but if you look at the holding of Park v. Sun, even though Park started to build the house for his own family, later sold it, they still found that the implied warranty, as a habitability case, the high warranty of habitability applied to him as a builder vendor. And right. I think there's a genuine issue back.
But workmanship, though.
Well, workmanship too. If he put the floors in 3 years ago, he painted the floors, painted the entire house. When we came in there, and council made a lot about this as we got to look at the house. The one fact he forgot to mention, when we saw the house empty, we already paid $693,000 for the home. Mr. Wisniewski stayed in the house for 3 days later. He didn't vacate till late at night, about 3 days after closing when it was dark. These are black floors. My client walked in, the house is empty. He looked around, it looked okay. It wasn't until he started doing remodeling and he started looking at the floors in the daylight and sunlight and saw when he moved removed the window fixtures that he saw all these damages.
But so if he knew about it, if he knew about that, he needed to disclose that. Right?
Correct. Well,
but that's not to Mr. Mathis's point that their contract was a contract for sale. If he violated a contract here, that's the contract he violated, and the provisions of the Disclosure Act he violated. He never contracted with the defendant here to do any work whatsoever.
No, but he is a builder vendor because he bought this fixer-upper from foreclosure. He completely remodeled it, put new floors in there. He painted the house. He put new fixtures in. He put these window fixtures in, and we have a right to rely that he did that correctly, especially since he made he made a profit on this. Under Parkview Zone, you don't have to be a full-time builder to have the implied warranty kick in. If you, a single use, the court found was enough to impose liability in that case. And that's Parkview Zone 89 ill second 453. So again, it's an issue of fact. It may be a trial issue, a fact issue, but for a motion for summary judgment, there's a genuine issue whether he was a builder vendor. There's no general contractor to assess liability. And the implied warranty habitability was created by the courts because it's unfair that homeowners, residential homeowners, when they buy a house, are stuck with a lemon. And the courts created this this remedy of implied warranty habitability to pass on the general contractor, the person who built it, because he has the duty to build it properly. And I also, he did testify at deposition of 10 South acquires, remodels residences, and improves bids. He did sell a house, and we counted the gross profit actually $183,000. And as part, he does qualify as a builder vendor. Now, the implied warranty workmanship, the same thing. If he put the floors in there, he claims he didn't know about the leakage, but when we removed the furniture, everywhere where there was furniture and windows, the floors were wavy. If you look at Exhibit 11, those are taken shortly after we moved in. Under implied warranty workmanship, both floors shouldn't warp and cup after 3 years. Either they were installed improperly or there was a massive water event. And if you look at, again, this goes into.
Well, wait a second, Posey, but isn't that really the point? I mean, and maybe I am missing something, so I just appreciate if you can explain that to me. I mean, you're not saying that the floors were installed wrong, right?
We don't know. Either they were installed wrong or there was a massive flood. It's flood an alternative. But he had a duty to make sure we had decent floors. I mean, floors don't go bad after 3 years unless there's some intervening event. Either they were put in improperly or there was, like, if you look at Exhibit 4, I mean, there wasn't.
As I read your inspector's report, isn't it they're saying that it was because of the water infiltration?
That's what they believe, it, the water infiltration.
I'm trying to think where I saw, and maybe you can point it out to me, where somehow someone said there's some evidence that the floors were improperly installed.
I believe the water infiltration, when they installed the floors, they had to make sure the water wouldn't get in there. So it's both either there was a massive water leak which he didn't disclose, or when you put because there was carpeting in the house, when he put the wood floors in there, he should have made sure that they would uphold the moisture problems there in the house. That leads to the other moisture issues that we found in the house also, which makes the house uninhabitable. The whole first floor is cut up with chunks of drywall. There's mold growing into pockets. There's rotted out window beams and headers. These are things, if he took upon himself to remodel and he gave us a beautiful spreadsheet of $108,000 of repairs, he should have done it properly. You don't assume that someone's going to do $108,000 of repairs on a house and show you all these line items and do a bad job. That's why they bought the house, based on the repairs and the appraisals that Mr. Schnepsky gave us.
Go ahead, anything further?
As to the implied warranties, Your Honor, there also, there's one more case we cited. I can just find it right here. The yeah. So again, the Illinois courts have held that when a builder makes significant additions to a home, this is the Von Holt case, an action for damage resulting from latent defects affecting habitability exists under the doctrine. So he built these repairs. He's responsible to make sure they're done in a proper manner. Can we move back on to the RPDA case? Or?
Yes, please go right ahead. I didn't mean to steer you off into another section. My notes are caught up now. Go right ahead.
Thank you, Your Honor. So again, just to repeat myself a little bit, we allege 5 categories of defects. He admitted to knowing about 3 of them. He admitted that he knew about the skylights, that he painted it. When we asked them about the skylights, they told us condensation. Today, counsel testified that he told us he did it every year. I don't see that in any of the depositions or any testimony. We were told it was condensation. We didn't know it was a yearly thing. But if you look at Exhibit 8, Exhibit 8, 1 second.
In your exhibits?
Yeah, if you look at Exhibit 8, at his deposition, when I showed Mr. Wisniewski the condensation, I showed him a picture. He said that was the leakage, but his spots were rust colored. These look black. So that's what he calls condensation. We had 2 expert witnesses testify. That's not condensation. Ms. Johnson testified that if you look at the damage at the corner at the top of the roof, that's clearly water leakage. Again, this is a person who claims in his affidavit he has no specialized knowledge. He never had anybody look at it. He never had a roofer go on there. He never had a window person check on it. He just painted over every year for 3 years. And then when we asked Mr. Shapiro asked him in his deposition, if you look at the picture, the corner, the drywall, did the leakage run down to the drywall like that? Yes. Well, how do you know it's condensation? It only happened in the wintertime. Again, that's something he had disclosed on the Real Residential Real Property Disclosure Act. He admitted that. At the very least, there's an issue of fact on that one. Now, as to the garage ceiling, when we asked him about the damage in the garage ceiling, he admitted he knew about that. He said he didn't want to fix it because it didn't bother him. But in the Real Property Disclosure Act, he has a duty to disclose all defects. And there's a specific question there: is he aware of defect? Is he aware of defects in the ceilings from windows? And he didn't disclose that. There's also the garage post. He claims he did it because of the posts, because of pebbles. But if you look at our expert testimony, she testified that concrete mix did nothing structural. All it did was conceal a defect. And when we broke through that thin layer of concrete and we dug the little pebbles, we saw that the house not had footings. Again, that's something you should have disclosed. If you look at the RRPDA case law, courts have held when a seller disclosed flooding, but didn't disclose the extent of flooding, that they were still liable in the RRPDA violations. Here, he never disclosed any of these things to us. He never disclosed that he paid in every year. He never disclosed that there's a giant hole in the garage, which is an active leak, which our witnesses testified that could only have been caused by water damage and would have left residuals, damage on the floor, insulation, chunks of drywall. These are things he should disclose. So again, for a person with no specialized knowledge in construction activities, Mr. Wisniewski took it upon himself to conceal these defects. He didn't fix them, he just covered them up. Okay, now so those are the 3 items that he admitted to. The other 2 items are in dispute. Now, the counsel kind of touched on this, but courts have held that generally a defendant's knowledge of a defect at the time of closing is a question of fact to be determined by a trial court. It's a question of fact. It's not something that can be determined on a motion for summary judgment. As you say, we have evidence here we discovered after we bought the house that he painted the skylight and the garage posts were damaged. And if you look at the Miserly case, they said a trier of fact does not need to accept a party's testimony if he had no knowledge of a particular fact in question if evidence shows the contrary. And the evidence does show the contrary. We bought the house in July when we started doing remodeling work. We removed the curtains and we see this giant bulge in the windowsill. And again, Mr. Hahn testified that to cause that much damage, that much water, there would be insulation, there'd be stuff that's falling on the floor. And it was concealed. If you look at the pictures, I believe it's exhibit, where are we at?
I did see
at 14. There was a giant bulge that existed at the time of closing. This is something he should have done. Now, he testified in his deposition that the windows were solid when he bought the house 3 years prior. Then he put up these window treatments. During the course between time he put up these window treatments and time we bought it, that's when the leak would have happened. Again, looking at a house for a couple of hours does not relieve the defendant's duty under Residential Real Property Disclosure Act. And there's case law to that effect. So, the courts have held that excuses, errors, or omissions that are based on reasonable belief that a defect has been corrected. The reasonableness of such a belief is a question of fact precluding summary judgment. And that's the Woods case 303 Illap 3rd 573. So these are all issues that can't be decided in summary judgment because they're just generally there's a dispute of fact. we move on. Again, so we were on the skylights. Okay. Now, also, when we looked at the house here, Mr. Vishnevsky testified he had the entire house painted. Yet when we removed the all the furniture and fixtures and we started looking at it, we saw an 18-inch layer above the paint of discoloration. Again, that's something that existed during his ownership. And Mr. Johnson testified the level of water that caused the floors to cup and that damage would have been significant. The homeowner should have known about that. Again, that should have been disclosed on the RRPDA form. And again, whether he had knowledge of it or not is a question of fact. Him saying that I didn't know about it is not sufficient to defeat a motion for summary judgment. Okay, so again, an issue of fact exists why the bottom 18 inches were discovered. Now, the windows. Sorry, I kind of threw off a rhythm. So give me a second. Okay. Now, Mr. Hanna, he testified when he did the inspection. Council asked him, could you move the windowsill, window fixtures? And he did. But Mr. Hanna also testified he didn't move furniture and he didn't remove the window fixture. So again, if you look at on the exhibit number 13, where the area of the damage was exactly where the window fixtures were, where those drapes and cornices were. And again, the amount of water that we showed in exhibit 14, there had to be a remnants of some kind of damage to cause that bulb. There would be cracking paint, insulation, and stuff like that. Now, moving on to the garage floor, Mr. Council says we didn't address the issue with the bulge in the floor. But as we argue in our brief, and if you look at exhibit number 16, that was the post when we bought it. It was clear and it was covered by that slurry. When we removed the post, we saw that there was no footings, and we look at there's no footings that caused the beam to split open and causing the bulge, and that's what caused the first floor. And our expert testified that a homeowner walking in it every day would have noticed a bump there. That's again something that he should disclose on our RPDA form, and he didn't. So we say actually the Posner versus Davis case where the court found concealing a flooding problem by removing damaged rugs and covering with a tile or covering the area with a rug was considered a concealment, and that's what we had here. Every avenue where we had the floors damaged happened to have a furniture. For some reason, we have a couch that's pressed right up against the window with a drape hanging over it. We have a zebra pattern rug. We have a changing table. There's a bookcase. When all that's removed, lo and behold, that area is where all the water damage was. So again, I think there's a genuine issue of fact why the furniture was placed that way. Now, council talks a lot about we should be able to discover this. But that ignores the purpose of the RRPDA. Legislature wanted homeowners to have security and have this disclosure. And cases have argued the Mitchell versus Skubiak that the employment of a home inspector does not serve to intervene the alleged act of concealment as between sellers and buyers. And we have active concealment. We have concealment of the garage post. We have concealment. We didn't disclose the leak, the condensation by the fresh paint, and the greater placement of furniture. So as they held in the Mitchell Skubiak case, the defendant had a duty to speak or disclose of defects to the professional inspector under same conditions as when the home inspected by a buyer personally. So under RRPDA, the courts have universally held that a buyer is entitled to rely on the truthfulness, accuracy, and completeness of the statement contained therein. And that's the Hogan versus Adams case. And in Hogan, the court specifically found that there's no language in the act that requires a purchaser to further investigate a disclosure of a defect beyond the report to determine its completeness. The council's whole argument is, well, you should have discovered this. You should have discovered that. Let's think about it. We have a thin layer of concrete. We made an offer to buy the house. Is it reasonable that a buyer comes in with a hammer and starts breaking stuff? I've never seen any case where a homeowner or a potential homeowner starts coming into a house with a hammer and starts chiseling away at concrete and taking over fixtures and moving furniture. That's why we get to rely on the Residential Real Property Disclosure Act form. They have to tell us about this stuff. And if he decides to play Mr. Fix-It with no specialized training, he should he could have disclosed on the form, hey, you know what? I covered up the concrete over there. Or I have to paint it every year. Because specifically ask on the RPDA form if there's problems with the walls, floors, and ceilings. And he admitted that every year he had to paint the house, the skylight specifically. So again, to sum up, the homeowner is not required to do further investigation. And he had a duty if he claims at the time he signed the RPDA form that these things didn't exist, they definitely existed by the time he bought it. So if there was an intervening event, intervening flood, he had a duty to supplement. Especially, he can't say in good faith that the house didn't have mold when he paid for water infiltration, when he paid for mold remediation in the basement. And when I show him the picture, is that where the mold was? Yeah, that was where the mold was. So he knew that there was water infiltration there. Now, again, I call your Honor's attention. Council talks a lot about the Smith versus Ethel case from 1984, but that's a unique case. That was not a Real Property Disclosure Act case. That was a case where a buyer is buying a commercial tavern. I think that case that's more on point is if you look at the Crute versus Sue Chan case, 2017 First District case, which we cited. In that case, very similar fact pattern. They looked at the house one time, they looked at the house a second time. After being offered, they did two separate inspections, and they specifically said that they noticed new carpeting in the basement and a smell of recent paint. And seller testified, oh, he painted it to make it look nice. But the court found that that was enough for a real violation of the Real Property Disclosure Act and the fraud case. So again, an issue of fact exists whether they violated the Real Property Disclosure Act and fraud. So, and again, I'm saying you to the Crute versus Sue Chan, 2017, ILAP first 162315, where the court discussed that. So again, the idea that you could have known about the freshly painted, that takes away their duty under RPDA. There's no case that says that. RPDA is specifically designed to protect homeowners. Seller had a duty to disclose all the time. Now, if we move on to the fraud item, the Bauer Court, Second District case from our circuit, basically decided that when a seller makes a material misrepresentation in the RPDA, the Real Property Disclosure Act form, that could be a basis for fraud. And that's what we have here. Blumen, we inquired about the painted skyline. We were told it's condensation, but that wasn't the case. They didn't tell us it was a yearly condensation problem. At the very least, they should have told us that they could have put it on the form and put a little notation here. We have to paint it every year. Then we wouldn't be here on the RPDA Act. But that's something that they had a duty, they didn't follow through with their duty. And again, if you look at the Bauer Court, a purchaser is entitled to rely on the truthfulness, accuracy, and completeness of the statement contained in the RPDA. And we cited the Mitchell versus Skuback, where a plaintiff inquired about a source of crack. The court held at that point a duty to speak arose on behalf of defense. So we asked Mr. Wisniewski, what's the source of condensation? He should testify like he did in his deposition. Oh, it leaks, and here's a picture of it. It goes all the way down. And then they would have known that it wasn't condensation because nobody other than Mr. Wisniewski said it's condensation. Our Mr. Johnson, or expert Ms. Johnson, Ms. Hannah, and Greg Feinstein both said that the amount of water to that kind of damage has to be from a leak. And whether it leaked, Ms. Johnson testified, water finds the lowest point to go. So it's not like, it rains today and it's going to leak tomorrow. Depending on the shift of the wind, depending on how the water falls, how it happens, that can be a leak. But we knew that this was a constant issue that Mr. Wisniewski knew about and didn't repair. And this was similar to, I forgot the case, I believe it's Posner versus Dave. I forgot the case here, but this was a chronic issue, but they had duty to disclose, they didn't disclose to us. Now, we did allege there's two types of fraud. There's misrepresentation of fact in terms of the freshly painted skylights and reliance on the statements, and then there was concealment. They concealed the water damage by creative placement of the furniture, the couch. It's abutted right by a window with a drape hanging over it, and all the other items in the rug. And there's actually concealment when they put concrete in there. Mr. Johnson testified that there's no structure, that concrete served zero structural purpose. The only thing it did was conceal the pebbles. And had the pebbles existed there, we would have been able to do further investigation or request to do some destructive testing to see the footing issue. Okay, and again, so with the concealment, Your Honor, Mr. Brodsky had duty to speak about that. So as we stated in the complaint, I believe that there's a genuine issue of material fact for fraud that prevents summary judgment. Now, we move on to the square footage. And this is an interesting one. Mr. Wisniewski never had to give us an appraisal. He chose to do here's an appraisal, here's how many square feet. But the interesting thing, and he testified, we got some discovery in his deposition, he had 7 appraisals. 7. When you have 7 appraisals with 7 different square footages, you don't pick the highest and best one and give it to your realtor and say, hey, here you go. He testified his deposition. He never told Mr. Wisniewski that he had, Ms. Melchin, that he had 7 different ones. So when he decided to provide the appraisal, he had a duty to make sure that the information was truthful. And we cited the Jordan versus Knoffel case when the defendant knows the disclosure fact would correct the mistake of the other party to basic assumption of the parties making the contract with non-disclosure, the fact that now it's a failure to act in good faith. That's what happened here. Had he not given us the appraisal, we wouldn't have a square footage issue. Now, counsel makes a lot of issues saying, well, they got their appraisal later, they could have looked at it. But if you look at, we cited this in our affidavits, when we got the appraisal, this is after earnest money has been increased. This is after a mortgage contingency has expired. This is after the attorney contingency expired. Then we get the appraisal, and they both testified they never even pay attention to it. They were looking mostly as to the facts. It only came up after the fact when we discovered all these other defects. So again, I think a genuine issue of fact existed. Why would he give one appraisal when he had 6 others with different? If he wanted to provide the appraisal, a complete picture is here's all 7, you make up your mind. But he made a misrepresentation that the house is 300 square feet more than it actually was.
You have, so your evidence is, because he says you don't have evidence as to the actual square footage of the house, you're saying you do, and that comes through your appraiser's report.
Well, yeah, we have our appraisal, and then we have what's in the county. The county showed the house is under 3,000 square feet. They made, if you look at the sequence of events, they call up to look at the house. As they're looking at the house, she tells Meltzer says, oh, by the way, the square footage is wrong. After we tell them we want a bigger home, the house is actually 300 square foot more, and here's an appraisal, and she texts the appraisal to my clients. And based on that, you know, they're all both Russian speakers, Miss Melchin and my clients. They assumed that she was accurate. Why would they assume that the appraisal would be different? She never told them, and I believe she didn't know from Mr. Wisniewski, there were 7 different appraisals. 7 different appraisals with 7 different numbers. He had duty to disclose or keep his mouth shut. But he created a false impression when he decided to selectively pick the best appraisal. None of the other appraisals were even close to that one. He picked the highest one. So again, he had duty. If he decided to disclose information, he had to correct information to make it a complete picture. Now, as to the settlement issue, this is an odd one. If you read the Joint Tortfester Contribution Act, 740 ILCS 102, it specifically says a settlement between one does not discharge any other tortfesters from liability for injury or wrongdoing unless the terms provide, but it reduces the recovery of the claim. Mr. Wisniewski, we filed a motion for a good faith finding. He didn't object. Our settlement agreement provides no release of Mr. Wisniewski. It would, under Joint Tortfester Act, reduce the amount we can recover for that issue, but it doesn't relieve him of liability. I believe that's more of a nonsensical argument as well. Covered workmanship. And then I don't know if counsel waived this or not, but he argued about the closing cost credit. But a closing cost credit cannot, he brought up in the brief, it cannot waive items we didn't know about. So we didn't know about the chronic leaking in the water from the skylight. We didn't know about the damage in the drywall, which he knew about, and specifically asks in the RPDA disclose if there's any defects in that. And the garage both self-concealed. So we can't leave stuff that we didn't know about. Again, the way the furniture was placed and the items were placed, it just, coincidentally, that's where all the water damage was. And we have Ms. Johnson and Mr. Hanna both testified there'd be a significant amount of water to cause that. The homeowner would have known. We have Exhibit 4 that they provided us shows that they did plumbing work and they removed sprinkler heads in that same area. When I asked him what plumbing work, he doesn't remember. When I asked what sprinkler heads, he doesn't remember. And again, he doesn't have a single receipt. He doesn't have a single canceled check when we asked for documents, all this stuff to prove that he actually even did $108,000 worth of work, which Ms. Johnson raised in her deposition. So I believe, Your Honor, if you apply the appropriate standard, you know, I think counsel at one point said he was doing a motion of limine to determine what was going to be tried at court. That's not why we're here. We're here on a motion for summary judgment. And I believe, looking at all the evidence in light most favorable to non-movement, which is the required standard, there are several genuine issues of fact that prevent summary judgment.
Thank you. Mr. Mathis, it's your motion, so you can have the final word on it, sir.
All right, I'll be brief, Judge. I think I talked it long enough. Just picking up on the last point, Judge. Genuine issue of material fact has to arise out of evidence. And that's why I emphasize the point that the plaintiffs have failed to produce any evidence that permit a reasonable person to infer that Dennis committed any sort of fraud. That's why I make that argument. And then I'd like to go back to Your Honor's questions on the the implied warranty of workmanship and the implied warranty of habitability. And counsel relied on the Park versus Sohn case. And he said, you know, multiple times, well, the defendant built the house and it was the first time he ever did it. And the court said, hey, you know, it doesn't matter that it's your first time and that you built it. You know, the implied warranty of workmanship applies to you. You're a builder vendor. It's just not true. There, the defendant had built 6 houses, sold them all, either before he moved out. He lived in them while he built them, sold them out either before he moved out or shortly after, and he held himself out as a general contractor. It's not the case here. No dispute about that. And then it kind of feeds into the other point that apparently counsel's making this argument that as a matter of law, anybody who doesn't hire a general contractor is treated as one. That's unreasonable, Judge. No case has ever said that. The last point on the implied warranty of habitability, the one point I didn't touch on is, Judge, there's no dispute that they've lived in the house ever since. The house is habitable. Just because they went in, their expert took some drywall off to look at a beam and they never put it back on, that doesn't make the house uninhabitable. The last point that I have that Your Honor asked a question on is the evidence as to the square footage. And Your Honor asked, you know, is your evidence the appraisal? And Judge, I'll tell you that the appraiser has not been disclosed as a witness. That was never brought in. So there will be no testimony from their appraiser at trial, if there is a trial. So they have no evidence at all. But
there is evidence that there were other appraisals with different square footage.
There's evidence of that, Judge, yeah. But there's no evidence as to what they even claim the square footage is. The basis that they have is they say, well, the 2980 that was in the original listing, no appraisal has that. No appraisal has that number. So they haven't established that that's the correct number. And then lastly, Judge, even if they did, even if there's a question about that, they can't rely on it because they have their own appraisal done and it showed a different number. So they can't just say, oh, I didn't pay attention to it.
There's going to be no evidence of that appraisal or that number.
I'm sorry?
Is there going to be evidence of that appraisal?
Yeah, I mean, just they've admitted that they had a deposition, that they had an appraisal done, and that the square footage was 3,099 square feet.
Okay, because I thought I heard you say that there was going to be no evidence of that appraisal.
Well, no, they can't. They don't have the appraiser to come in and say this is the accurate square footage.
Okay.
That's my point, Judge, is they can't establish that my square footage is wrong through their appraisal because they're not bringing him in. I think that's all I have, Judge. And, you know, to just kind of get back to your point, I bring this motion because, like I said, it's sort of a shotgun complaint that talks about all these different areas of the house. And I think at a minimum, Dennis has a right to know what claims he needs to prepare for trial. And I think I explained the different areas of claims and where the evidentiary shortcomings are for each claim. So, Your Honor, I submit that he's entitled to judgment on the entire complaint, but at the very least, in part. And that's all I have today, Judge. I thank you for your time.
Thank you. Thank you. The court has considered all of the documents that were given to me, including the motion, the response, the reply, all of the attachments, including the affidavits, photographs, the depositions, the admissions that were contained therein. Now, when I look at a motion for a summary judgment, obviously it's appropriate when the pleadings, depositions, admissions, and all those other things I just mentioned show that there's no genuine issue of material fact and that the moving party is entitled to judgment as a matter of law. There are many cases out there that talk about the nature of summary judgment. It's certainly not an impossible standard, but the cases do tend to say that it's a drastic remedy and a drastic means of disposing of litigation and should be granted only when the moving party's right to judgment is clear and free from doubt. Where material questions of fact remain disputed, then summary judgment cannot be granted. And then, we're talking about, and then we've looked back and forth at certain things. So, I'm just throw one out for a matter, and that has to do, say, with the let's talk about the footing issue and the cementing of the footing and why it was done or where it was done. And one of the things we talk about there is where a reasonable person could draw divergent inferences from undisputed facts. Also, summary judgment should not be denied. I'm going to go through some of these things that we talked about here today, and I'll be mentioning some of the law as well. But before we do get started, I just want to talk about that implied warranty of workmanship. This was a contract to purchase a home. There was no contract here for any kind of workmanship between the plaintiff and the defendants in this, or the plaintiffs and the defendant in this case. They didn't contract for those services. They contracted for the purchase of a home. And if there were problems with that came up later, whether it was in the disclosure or the habitability, whether fraud was committed, whether there's a violation of an act, they may seek remedy elsewhere, but they can't seek remedy for this as an implied warranty of workmanship. And for that reason, as a matter of law, I believe that defendant is entitled to summary judgment regarding that particular count. And I take that out of it because the others are more fact-laden than they are as a matter of law. Here, it's because there was no contract. As a matter of fact, they had a contract. The contract was specific contract for purchase, not a contract between a builder and a purchaser. And the fact that he had work done on it prior to the purchase does not change that fact. All right, so when we look at these other factors here in the warranty of habitability, fraud, the Disclosure Act, we are talking about, to a certain extent, what was the defendant's knowledge at the time he sold regarding the defects that are alleged. We've all talked about, I think it was cited, the Messerly versus Boemke case from the 4th District that said a defendant's knowledge of a defect at the time of closing is a question of material fact to be determined by the trial court. Or is there a jury demand in this case?
No.
No?
They withdrew, yeah.
I'm sorry?
There was one initially, but they withdrew it.
Okay. Further, a trier of fact need not accept the party's testimony that he had no knowledge of a particular fact in question if the evidence shows to the contrary. You know, I think we mentioned was the Woods case in which there was evidence of numerous prior fixes. Certainly, we don't have anything that extreme here, especially when we talk about, say, the skylight. But there was evidence that the skylight was painted every year. And I believe that there's a question as to whether that was done, at least a question of material fact as to whether or not that was done to conceal a chronic condition that turned out to be a leak, as plaintiffs allege here, or whether or not it was just condensation that was appropriately disclosed, or whether it was something else. You know, as we look at this, a seller who discloses information can be subject to liability under the Act if the seller knows information disclosed contains a material inaccuracy or omission. So it's not just a matter of that you disclose something and therefore it puts a burden on the plaintiff or the buyer in this case to then inquire further. He has a right to rely on not only the disclosure, but also the extent of the disclosure that was made. A trial court's reliance on defendant's good faith belief, and for instance, I'm talking about the Woods case, that a roof had been repaired was inappropriate. Although the Disclosure Act excuses errors or omissions that are based on reasonable belief that a defect has been corrected, the reasonableness of any such belief is generally a question of fact, precluding summary judgment. And also, in Hogan versus Adams, they say that while a disclosure report is not a substitute for inspection or warranties, a purchaser is entitled to rely on the truthfulness, accuracy, and completeness of the statements contained therein. If a buyer's knowledge of a defect does not relieve a seller of the liability under the Act. You know, and that has to do with whether or not, just as an example, the hole that was in the garage ceiling was something more than it was disclosed. In this case, under the Residential Real Estate Disclosure Act, the fraud, where a defendant's lack of knowledge and his reasonable beliefs are essential elements not only of the cause of action, but of his defense, circumstantial evidence will often, if not necessarily, be an important aspect of the plaintiff's case. Otherwise, an admission by a defendant would always be required and necessary to prove liability. Plaintiff has a right to rely on that circumstantial evidence in his pleadings, as they do here. Whether it ultimately carries the day at trial is a question of material fact that is going to need to be determined at the time of trial. Here we do have a number of questions of material fact that I believe still need to be addressed. And I'm just not going to talk about all of them, but, you know, did the defendant misrepresent and conceal the nature of the alleged defect to the skylight, whether it was condensation or a leak that developed after it was sold, and that the paint was only there to cover up discoloration by condensation, or was it something more that he had knowledge of and didn't fully disclose, as is alleged here? Did the defendant have no knowledge of the issue with the garage footing or structural issues as they existed, or did he cover the area with cement to keep his child from playing with the pebbles? I mean, that's a question of fact that's going to have to be determined. did the defendant intentionally conceal warped flooring using placement of furniture and rugs and not disclose the fact that there was significant water infiltration that closed it that he knew about? Or did the problems with that significant infiltration start after the sale? Those will be questions of fact, need to be determined by a trier of fact. You know, the defendant admits that he knew about damage to the garage ceiling. You know, and, you know, that never disclosed. We don't know. Was he expecting the plaintiff to find it on his own? Why wasn't it disclosed? Or did he fail to disclose it because he didn't think the plaintiff would, or didn't want the plaintiff to discover it? And then, of course, there are numerous issues of fact regarding the square footage based on the other I shouldn't say reliable, but on the other appraisals, and that the fact that there were so many appraisals done, and the fact that he only disclosed the one with the most square footage could be seen as raising a question regarding, you know, his intent in that regard. You know, whether or not the plaintiff could have or could not have discovered some of these defects through a reasonably diligent search is still an open question, a material fact that has not been conclusively dispelled as a matter of law by what's been presented here. You know, where the dam, and I go on the same thing about the damaged windows in the dining room having been painted over, or was that done to conceal water damage from a significant leak that somehow, that also that cracked the header over that window. And then, of course, there's sort of when it comes down to the evidence presented here, and as it concerns intent, there's a totality of the circumstances, totality of the evidence, both circumstantial and direct, and what that says about the defendant's intent, knowledge, or reasonable beliefs under these circumstances. I am not commenting certainly on the strength of the evidence in this case. The only question here before me is whether there are issues of material fact to be left for trial. You know, whether or not, as I said before, any of these arguments or evidence carries the day at trial is not for me to determine right here. But based on what's presented, the court does find, as I just said, questions of material fact that need to be resolved at trial. And based on that, as to the other counts, I'm going to deny the motion for summary judgment. I'm going to need an order stating these things. Do you know where to send the order to?
Yeah, I think the email's online, right?
Yeah, now why don't we I'm going to give you the email address, because email it to me and I'll review it and sign it after the two of you exchange it. But
Yeah.
do it to cc205@lakecountyil.gov. I might even hit. You got that? So it's just like the other address, except it's 205 instead of 202. I think is where this case came from. So it's cc205@lakecountyil.gov. And if you could have that to me, you know, before 2 o'clock today, that would be great.
Yeah, sure thing, Judge.
Does that leave you guys enough time?
Yeah. The only thing was, I don't know if you clarified on the warranty of habitability.
I do find there's a question of fact regarding the warranty of habitability, whether or not, you know, there's a question as to whether or not, and as I said before, I'm not commenting on the strength of the evidence, but there is, I think, enough evidence to go forward as to whether or not he was someone who bought this house to flip it based on his experience in the industry that he was in, the amount of money he put behind it, the way that the thing was, that the home was sold. You know, it does appear he bought a house in foreclosure, fixed it up and sold it. There was a significant amount of work done. I do think there's a question there. And I am going to, and whether it's whether they're still living in it or not, I don't think is the ultimate question when it comes to habitability. I'm not saying that they don't have a heavy that they are not going to have to take a more labor or when it comes to proving that they did in summary judgment. But I am going to allow the count on warranty of habitability to go forward.
Okay.
All right. Anything further?
Yeah, Judge. So basically now, everything, all that's left is trial.
Yes. Do you want another date? When do we? Is there a trial date set?
It was, Your Honor, back in May. That was stricken pursuant to COVID.
Okay, I can give you guys a trial date now. And if you would like, I'd be happy to give you a pretrial date as well, if you would like the court's assistance in pre-trying the case.
Yes, Your Honor. We had a pretrial settlement conference scheduled. All that got canceled because of COVID. So,
Okay.
So, Your Honor, we're going to be in front of you from now on?
No, it still goes back to Judge Hoffman. It's his case. He just sent it to me for hearing on the motion for summary judgment. It'll go back to him. Whether he assigns it out to me for any other purposes will depend on his availability and mine. You know, if he's not available to hear it, that's when he gives it to a backup judge such as myself. So I have no idea. But I can get you dates, though, if you want to set a trial date and another pretrial date in the matter, which I think is.
Sorry, Your Honor, as far as trial dates, are we going to do it in person or how?
No, it would still be, for a bench trial, it would still be done via Zoom. And we do have a bench trial protocol, which you could find on Judge Hoffman's courtroom site that will tell you exactly what the protocols are for bench trials. And it also has his standing order regarding bench trials as well for this COVID, under the COVID restrictions. So you can find those on his courtroom has its own website.
My only concern, Your Honor, because everything's now done by either Zoom, we can't a lot of times be in the same room with people. We need to have maybe a longer date so we can get everybody. We have a bunch of witnesses to get prepped and documents.
That's certainly fine. We can do that. I will just tell you, I encourage you all to read not only Judge Hoffman's standing order, but also the bench trial protocol, because it will tell you that, for instance, the exhibits that you're going to be presenting. I know we have exhibits here already, but you're going to have to, it talks about how you're going to present those. So, you know, you're going to have to get those to Judge Hoffman in advance of the trial date so that he'll have those there, because obviously you won't be handing exhibits up to him at this virtual bench as it goes forward and things such as that.
And then as far as subpoenas and stuff, that would be, well, I guess the subpoena them in normal course and have them in front of the, have to figure out how to get somebody to testify if you assume a subpoena. That's going to be interesting.
Yes. Why do you have unwilling witnesses that you're doing?
Well, I think, well, depending on what we can work out as far as what we'll stipulate to, but we have a significant number of witnesses, and I think a couple of them are going to be adverse. So, you know, if I, you know, I'm just thinking through, if I subpoena somebody, he doesn't have a computer, so we have to arrange somewhere for him to go. So,
yes, I mean, they can, you know, we have very simple instructions regarding how to use Zoom. Most people are able to do it. They can do it either, you know, via video or telephone. They could come to the courthouse. We have stations here in the law library where they can participate in the trial from there and take their testimony. So there's a number of ways that it can be done. And as I said, if you take a look at the protocol, it'll go through all those.
we'll do your own.
Maybe also we can, you know, I'll set a pre-trial date, and if there's questions, you could answer. Judge Hoffman will be able to answer that at the pre-trial date as well.
Yeah, will this be the court's the 218 final pretrial where we give exhibits, or is it going to be a settlement pretrial date?
You are entitled to. You can have either or both. You know, if you want a separate pretrial date earlier, in which you want to see if you can settle the matter, that's fine. If you want to do it at the final trial conference, along with the exchange of documents and to make sure that everything is in place, we can do it at that time as well.
I mean, because of the 218 where it requires so much stuff to be ready for final pretrial, maybe it makes sense before we spend thousands of dollars to do a settlement trial and then do a second final pretrial, because that's going to take a lot of work.
Mr. Mathis, what's your thoughts on that, sir?
Yeah, I think it makes sense to separate it. I mean, the sooner the better, probably, but yeah, I think separate is a better idea.
Okay. Let me just ask you, first of all, if I was going to set a trial, then how far out would you want to go? And then we'll work backwards from there.
I don't, what's the longest date you're on we have at this point? Or what dates are we giving out?
I could go find out, but you know, I would say this is June, July, October, October maybe.
I think October, hopefully by then we're out of COVID.
Yeah, November maybe even. I could go find out those dates. If you want to just give me a moment, I can find out some dates for you. You can just give me 5 minutes. I'll go do that right now.
Thank you, Aaron.
The conference clerk will be the one I need to consult on that. So,
Thank you.
all right. So why don't we do take 5 minutes? I'm going to mute myself. You guys can continue to talk. Please remember that you're on YouTube Live though. At this point, actually, I think if the proceeding's done, I can stop the live stream on the matter. Would both parties want me to do that? That way,
That makes sense.
to talk with each other to finalize the order. I'll go get the dates and come back.
I think it makes sense.
Is that agreeable to everybody?
Yes, Judge.
Okay.